When you hear the phrase, "you've been served," what's the first thing that comes to mind?
Oh, it's always drama, right? Some kind of confrontation.
Exactly. Avoidance, maybe a chase scene from an old movie. It sounds like something that it happens to you.
It absolutely does. But today, we're going to dive deep into a strategy that really flips that whole idea on its head. Okay. Our sources, and they focus really heavily on the procedural rules around the 19th Judicial District Court in Baton Rouge. They show that service of process isn't always a confrontation.
Right.
It can actually be a calculated, strategic move, something you manage entirely on your terms.
So that's our mission for this deep dive. We're looking at the source material to find out how individuals and businesses can proactively accept service legally.
Instead of waiting to be chased down.
Yeah, we're looking for the ultimate shortcut to procedural compliance.
And we have two main paths to explore here. The first one is a pure business decision appointing an agent, a strategic move.
And the second?
The second is more of a procedural shortcut for individuals, voluntarily signing a waiver.
And both are about what, really? Gaining control.
Gaining control over the timeline and saving money, which, if you've ever dealt with the legal system, that's the biggest efficiency there is.
No kidding. And this isn't just some dry legal theory. For a company in the capital region, getting this right, it can be the difference between defending a lawsuit and what?
Facing a catastrophic default judgment. And for an individual, it's the difference between a quick, amicable settlement and just months of delay and cost.
Okay, so let's start with the business side of things. The stakes there feel enormous.
They are.
So let's focus on that strategic piece, appointing a registered agent. We're talking about every corporation, every LLC, doing business in Louisiana. The sources make it really clear it's fundamental. This is not some optional convenience.
No, it's mandatory. It's actually codified. We're talking Louisiana Revised Statute 12.1501. The law plainly states that every single business has to designate a registered agent.
And that agent has to have a physical address, right? To accept lawsuits for the company.
A fixed physical address. It's the state's way of making sure that if someone needs to sue you, they know exactly where to find you, legally speaking.
Okay, so here's the strategy part. A lot of small business owners might just think, oh, I'll just list my home address, or I'll handle it myself at the office. But what is the crushing risk of doing that?
The risk is total, and it has a name. The default judgment.
Explain that.
Okay, imagine this. You failed to designate an agent, or maybe the person you listed wasn't at their desk between 8 a.m. and 5 p.m.
They went to lunch.
They went to lunch at the wrong time. The plaintiff can then legally tell the court that service failed, and they can ask the court to enter a default judgment against your company.
Wait. So a judge can actually rule against a business without the owner ever seeing the lawsuit?
Without them ever seeing it, yeah.
Just because someone was out for an hour?
Precisamente. The court assumes you were legally notified because your mandated agent wasn't there. You don't get a second chance. The clock to answer the complaint starts, and then it expires, all without your knowledge.
Wow.
This is why paying for professional service is less of a fee and more like a very important insurance policy.
That completely reframes the whole thing. It's just pure and simple risk mitigation. So let's dig into the reasons our sources highlight for hiring a professional service. The first one is privacy.
Yes. Think about that image we started with. No one wants a sheriff's deputy or a process server knocking on their door during dinner with the family.
Right.
If you list your home address with the Secretary of State, that's public record. And that's exactly where the lawsuit is going to land.
So the service just keeps the legal stuff away from your personal life.
Yeah.
That image alone, the mashed potatoes hitting the floor, that's a pretty powerful reason.
And beyond privacy, you get absolute compliance. A professional service guarantees someone is there. 8 a.m. to 5 p.m., 5 days a week.
Regardless of holidays, sick days.
Anything. It just removes that risk completely. The risk that service would be defective because your agent wasn't physically present.
And what about the speed advantage? Because getting served starts a legal clock, and every single hour has to count.
This is a huge tactical advantage. When a professional agent gets those papers, they have systems. They immediately scan and email them to you.
So you get them almost instantly.
Often it's same-day service.
Yeah.
And look, if you have maybe 15 or 20 days to respond, gaining an extra day, even just a few hours, that's gold. It gives your attorney more time to strategize.
And location seems to matter in this game, too. These services aren't just set up anywhere.
Oh, not at all. It's meticulous.
Yeah.
They often position their offices just minutes from key places. The Secretary of State, the 19th JDC Courthouse, the Federal Middle District Court.
So that proximity helps with filings and things later on.
It just keeps the whole legal machine moving efficiently.
Okay, so that really covers the defensive strategy for businesses. Now let's pivot. Let's go to the other side. Efficiency for individuals. Because if the corporate world is about defense, this is about speed. Not every lawsuit starts with a big fight.
That's a great way to put it. We're now in the world of amicable situations. Think about uncontested divorces, friendly business dissolutions, simple property settlements.
Where everyone agrees on the outcome.
Exactly. You're not trying to surprise anyone. You're just trying to get through the court's requirements as fast as possible.
So in that case, why would a defendant choose to just voluntarily accept service?
It saves everyone time and money. I mean, the plaintiff doesn't have to hire a process server, which can be expensive, and they avoid the headache of trying to track you down.
So by volunteering, the defendant just speeds the whole thing up.
Immediately, it accelerates the whole timeline to the final resolution.
Okay, so let's walk through the actual document. What's the specific form required for this shortcut?
The document is almost always called an acceptance of service and waiver of citation.
And what does it need to say to be legal?
Two things, very clearly. One, that the defendant has received a certified copy of the petition, the actual complaint. And two, that they explicitly waive formal service. They're basically saying, don't send the sheriff, I've got the papers.
Now, this next part feels like the most critical detail. This isn't just about signing a piece of paper, is it? There's a gatekeeper involved.
Yes, and if you miss this step, the whole amicable process just grinds to a halt. The form generally must be signed by the defendant in front of a notary public.
A notary public? Why is that step so vital? Why can't the two people just sign it and send it in?
Because the court needs to be sure that the person signing is actually the defendant and that they signed it willingly.
Okay.
The notary is that impartial witness who confirms their identity and that they weren't forced to sign. If that notarization is missing or it's flawed, the judge will just throw it out.
And then you're back to square one.
Back to square one. The plaintiff has to go pay for a process server and the clock starts all over again.
So the one step you took to save time ends up wasting months if you don't do it perfectly. That says a lot. And once it's signed and notarized, where does it go?
It has to be officially filed into the court record at the 19th JDC, that's at the courthouse, 300 North Boulevard in Baton Rouge.
Which again is why using a service that can help with that part is probably a good idea.
It guarantees it's done right the first time.
Okay, we have to talk about the psychology here. The biggest barrier. If someone hands you a lawsuit and says, sign this acceptance of service, your gut reaction is going to be,
Am I admitting guilt?
am I agreeing with what they're saying? Yes.
And that's the crucial misunderstanding. You are not in any way agreeing to the claims. Signing that waiver does one thing, and one thing only. It acknowledges that you received the papers.
It just starts the clock for your response.
Just starts the clock. It is purely procedural, not substantive.
That's a huge distinction. It's like saying, I got the mail, not I agree with the letter.
Exactly. You're controlling the logistics, not conceding the argument.
Perfect. Okay, let's get into the deep procedural weeds now. Because this is where things can get really tricky, especially in complex cases. Serving a party by serving their attorney.
Service on representative. This is a very technical point. It's governed mostly by Louisiana Code of Civil Procedure, Article 1235.
And it has some really strict rules about who can accept those papers.
Extremely strict. This is the kind of detail that can absolutely make or break a case if it's not handled perfectly.
So what is the hyper-specific requirement for serving an attorney at their office?
The rule is precise. Service is only valid if it is delivered personally to the attorney themselves or to the attorney's secretary in their office.
And there's the catch. We have to define secretary. It's not just the person at the front desk of a big law firm, is it?
Absolutely not. And that's a really common failure point.
So if I'm a process server, I can't just drop the papers with anyone who answers the phone.
No. You have to be sure that the person accepting them fits the legal definition of a secretary or someone who is authorized. If you just drop the papers with a general receptionist in the lobby, the service is defective. It's no good.
Okay, let's run a hypothetical. A plaintiff spends a month, hundreds of dollars, trying to serve a big corporation's lawyers. They finally get to the office, hand the papers to a very cheerful but unauthorized lobby assistant. What happens down the road?
Months later, the defendant's lawyer stands up in court and says, "We were never properly served." They file a motion to quash the service.
And the judge?
If the judge agrees that the lobby assistant was not a secretary under the statute, the whole service attempt is invalidated. thrown out.
All that time and money just gone.
Wasted. And the entire case timeline is derailed. You have to start the whole process over from the beginning.
So that one tiny detail, the job title of the person who took the papers, can completely obliterate the timeline.
It proves that knowing the procedural code is just as important as knowing the facts of your case. It is a logistical problem that demands a logistical solution.
So pulling this all together, what we've really established is that service of process doesn't have to be this blind defensive reaction.
Not at all. It can be a fully managed logistical challenge that you take complete control of.
For businesses in that 19th JDC area, it means using a registered agent to ensure compliance, protect against that default judgment threat,
And secure those crucial time advantages with fast electronic delivery.
and for individuals in those more amicable situations, the acceptance of service waiver is just a massive shortcut.
It saves time, it cuts costs, and it gets you to the finish line faster, as long as you get that notary public signature right.
Now, we've given you the procedural roadmap here, but it's really essential that we add the necessary caveat from our source material.
Yes, this deep dive is based on information from a professional process-serving agency. So this content is for informational purposes only. It's to help you understand the logistics.
We are experts in breaking down complex information, not in giving legal counsel. This is not, and it cannot be, legal advice.
Absolutely. If you're a business owner wondering about an agent, or if you're an individual being asked to sign a waiver, or you're questioning any part of your own legal situation,
You have to consult a qualified Louisiana attorney.
that professional legal advice tailored to your specific case is indispensable.
That's the ultimate takeaway. Know the rules, but know when to call in the pros. But let me leave you with one final thought to mull over. We've talked about the costs of getting this wrong, right? The threat of a default judgment, the months of delay from a missed notary signature, having service thrown out over the wrong receptionist. Given those high stakes, what is the true value of getting professional, precise, procedural help?
It's a great question. Challenge yourself to think about the cost of delay, the cost of error, the cost of catastrophe, and hopefully you can use this knowledge to navigate the legal requirements in Baton Rouge, not with fear, but with a lot more confidence and a clear view of the strategic rules of the game.